Nowadays, one of trademarks worth billions of dollars. For example, according to Forbes magazine, three most valuable trademarks in 2016 are Apple, Microsoft, and Google, valuing 233.7, 87.6, and $21.9 billion respectively. Because of their values, their position is different from other original marks. So in this video, I'm going to talk about one of trademarks and their position. Here is my outline. First, I will explain the definition of one of trademarks under international conventions and the Trademark Act 1995 Australia. Then I will move to the position of one of trademarks under Australian legislation. The last part is conclusion and references. To begin with, do you remember what a trademark is? If the answer is yes, wow, you're really good at remembering. If no, no worries, I will help you. Under Section 17 of the Trademark Act, a trademark is a sign and used to distinguish goods or services. A sign, in turn, includes any letter, word, name, signature, number, device, brand, heading, label, ticket, aspect of packaging, shape, color, sound, or scent, or their combination. This means that almost anything that a person can discern with their senses is able to be a trademark. The first part is definition of one of trademarks. Firstly, although one of trademarks are not defined under international conventions, several factors can be considered to determine whether or not a trademark is one of, as set out under the TRIPS agreement and the Whiteboard Joint recommendation. For example, Article 16.2 of TRIPS agreement states that state members shall take account of the knowledge of the trademark in the relevant sector of the public, including knowledge in the member concerned which have been obtained as a result of the promotion of the trade. Article 2.1c of the Whiteboard Joint recommendation also suggests that state members need to consider several factors for one of trademark determination. So let's take a look. First, the degree of knowledge or recognition of the mark in the relevant sector of the public. Second, the duration, extent, and geographical area of any use of the mark. Third, the duration, extent, and geographical area of any promotion of the mark, including advertising or publicity and the presentation at fairs or exhibitions of the goods and/or services to which the mark applies. Fourth, the duration and geographical area of any registrations and/or any applications for registration of the mark, to the extent they reflect use or recognition of the mark. Fifth, the record of successful enforcement of rights in the mark, in particular, the extent to which the mark was recognized as well-known by the competent authorities. And sixth, the value associated with the mark. However, these factors are simply guidelines to assist the competent authority to determine whether or not a mark is well-known, and are not preconditions to reaching that determination. Rather, the determination in each case will depend upon the particular circumstances of that case. Secondly, under the Trademark Act of Australia, one trademarks are also not defined. However, some minimal assistance is provided by Section 1204 of the Trademark Act, stating that one should consider the extent to which the trademark is known within the relevant sector of the public, whether as a result of promotion of the trademark or for any other reason. Criterion for determining the relevant sector are developed by Whiteboard, including actual potential consumers of the type of goods or services in relation to which the trademark is used, persons involved in channels of distribution of the type of goods or services. Whiteboard has also stated that a trademark need not be well-known by the public at large in order to be a well-known trademark. Now let's move to part 2, the protection of well-known trademarks. There are 4 requirements are mentioned under Section 120, subsection 3 of the Trademark Act, which provides protection for registered and well-known ones, including this infringed trademark being well-known, being used in relation to unrelated goods or services, the infringing trademark indicating a connection with the owners, and the owner's interest adversely affected. The well-known requirement is mentioned in part 1, so I won't talk about it again. The second requirement is that the defendant must use a sign that is substantially identical with or deceptively similar to the plaintiff's trademark, as a trademark in relation to unrelated goods or services. Unrelated goods or services are explained as not of the same description or closely related to the goods or services for which a well-known trademark is registered. Goods may be totally unrelated, largely unrelated, or insufficiently related to be considered goods of the same description. The next requirement is indicating a connection with the owners. The interpretation of these words in Section 120, subsection 3 will turn very much on the meaning of the word connection. There are at least 2 possible meanings. One identifies the subsection as an equivalent of passing off, while the other one is consistent with Section 120, subsection 3 being an anti-dilution provision. However, whichever interpretation is taken, some assistance in determining the necessary connection for these purposes may also come from the provision dealing with defensive registration under Section 185, subsection 1. This provision requires an applicant for defensive registration to demonstrate that the use of the applicant's trademark would be likely to be taken to indicate that there is a connection between the goods or services for which defensive registration is sought in the applicant. Therefore, it is a reasonable assumption that the connection required for the purpose of Section 185 is the same connection required for Section 120, subsection 3. This provision Finally, the owner must demonstrate that because the sign will be likely to be taken as indicating a connection between unrelated goods or services and the registered owner, the interests of the registered owner are likely to be adversely affected. There are also 2 possible interpretations for adversely affected, depending on whether the provision is an equivalent of passing off or anti-dilution. If this provision is passing off, the affected interest may include loss of the chance to penetrate it, or greater difficulty in penetrating the market for the goods or services being supplied to the defendant, loss of licensing fee, or loss of custom. If it is anti-dilution provision, the affected interest may be the general dilution of the value of the plaintiff's trademark. So the question is that whether Section 120 or subsection 3 is anti-dilution or passing off provision. It is true that this provision is not anti-dilution because anti-dilution requires intellectual relation between the product side and the well-known mark, whereas Section 120 subsection 3 requires different relation between the side of unrelated goods or services and the register holders. If Section 120 subsection 3 is not an anti-dilution provision, it is not easy to identify any circumstances in which infringement based on this provision would not also constitute passing off. In fact, both Section 120 subsection 3 and passing off require an actual reputation in Australia and an unauthorized association or connection with the plaintiff. In conclusion, there are several key points to remember. First, well-known trademark is not defined in Trademark Act 1995. Second, the determination of well-known trademarks depends on particular circumstances. Third, there are 4 requirements for well-known trademark protection. Well-known is in relation to unrelated goods or services, the infringing trademark indicating a connection with the owners, and the owner's interest adversely affected. And 4. Section 120, Section 3 is not anti-dilution provision. So, here are my references. And thank you for your attention.